Hello, and welcome to this video on the new European Account Preservation Order. My name's Sarah Garvey. I'm counsel in the litigation department at Allen Overy. We're here today to talk about why, as a litigant, you may want to apply for a European Account Preservation Order. As a defendant, what are the risks of your accounts being attached? And as a bank operating across Europe, what are the obligations that you'll be under when you receive one of these orders? A European Account Preservation Order, or an EAPO, as we've described them, this is a new piece of European legislation which introduces a mechanism for participating member state courts to issue an order to freeze a defendant's bank accounts, their cash accounts, across participating member states. So it's a single order that is made by the issuing court that then gets transmitted to different member states where that defendant has an account or is thought to have an account. It's a single process. The EAPO will come into force on the 18th of January 2017. The UK courts, however, will not issue EAPOs, and this is because back in 2011 the UK government issued a consultation seeking views as to whether or not the UK should exercise its opt-out in relation to certain legal matters. Now, following that consultation, the UK government took account of views expressed and said that they would opt out of this particular measure. So the UK is not bound by this legislation. Denmark has also opted out of this legislation. So the courts applying the EAPO from the 18th of January 2017 will be the participating member states in the 26 other member states. Even though the UK courts will not be issuing EAPOs from January 2017, UK companies, UK businesses do need to be aware of this measure because they may well have accounts in the 26 participating member states, and these accounts could conceivably be attached pursuant to this measure. So businesses with accounts in France and Germany and Italy, their accounts might be attached if, for example, proceedings are started against them in the courts of France and the French court issues an EAPO to freeze that UK defendant's accounts in France, Germany and Italy. So that's one reason that UK businesses need to be alive to this measure. The position in relation to UK consumers is different, and we don't think that they would be covered by an EAPO issued from a participating member state, at least currently. Another reason why UK businesses may need to pay attention to this measure is that they may be banks, and banks operating across Europe will need to have in place systems and processes to deal with receipt of these orders because the banks have a responsibility to freeze the accounts and then issue a declaration. The EAPO differs from an English freezing order in a number of respects. First of all, it's an order just attaching the cash account. It's not freezing assets more widely. The process for getting the EAPO is very different from the process for getting an English freezing order. The first difference is that it's a paper application. You fill in a standard form document, maybe attach relevant documents to your standard form and submit it to the participating member state court. There is generally not an oral hearing. Now, this is very different from an application for an English freezing order, where generally a party would attend before the court and the court would ask questions before issuing any freezing order. Now, the EAPO procedure, it is ex parte, like an application for an English freezing order, but it is on paper and follows a standard form. So that's the first key difference. The second key difference is that An EAPO can be then transported from the court issuing the EAPO to other member states. And there is a mechanism now set out in this European regulation for the transport of the order to different member states. And this, again, is very different from an English freezing order. The mechanism for transporting the EAPO from the issuing court to other member states is quite complicated, and the regulation envisages participating member states creating what are called competent authorities and setting up competent authorities that will deal with the administration of the order. So when they receive the order from another court, they will send it out to the banks within their jurisdiction. And then when they receive information back from the banks, they then transmit that information back to the issuing court in most cases. So there's a whole mechanism, a whole framework envisaged in this European regulation, which just doesn't exist with the English freezing order. There are other variations, mainly technical, some procedural, between the two measures. But I think principally it's that the EAPO is just focused on the cash accounts in the name of the defendant or held on the defendant's behalf by a third party if the relevant enforcing member state permits that route. How will an EAPO work in practice? Well, in participating member states, if you're a claimant, you can apply for one of these orders before proceedings have even started, during the course of proceedings, or indeed after proceedings have concluded and when you already have your judgment to aid the enforcement process. If you're a claimant and you're looking to get an EAPO at the very start of the dispute, so perhaps before you've started proceedings, you need to fill in your form. You should be able to do it online. You will need certain information about the defendant, their name, address. You'll need their account number and their IBAN number, for example. And you will need to satisfy the court that there's an urgent need for the order, partly because there's a risk of dissipation, and that you have sufficient evidence to satisfy the court of this urgent need. You will need to attach documents supporting your claim, because if you haven't got your judgment, you need to explain why you think that you're going to win your case. You also need to indicate why you say that the court that will issue this order has jurisdiction in the first place, and you actually need to tick a box to set out the jurisdictional basis of your order. So the court will then consider the paperwork, and importantly, as a claimant, you will need to offer security and provide security to make that application if you're making your application before you've got a judgment. So in that early stage, a claimant will be required generally to provide security in aid of its EAPO order. Now, in the post-judgment context, so when you've already got your judgment, a claimant won't generally have to provide security. So there is a difference depending on what time of the procedure, what time of the dispute you're actually making the application. Now, once the order is made by the issuing court, it is then transported to the relevant jurisdictions where you as a claimant think that a defendant has its bank accounts. So, for example, if you start proceedings in Italy, and Italy is the issuing court, and you indicate in your application form that you think that the defendant has bank accounts in France, in Germany and Holland, the issuing court would send off those orders to the competent authorities in the relevant jurisdictions, and those competent authorities would then send on the order to the relevant banks in Germany, Holland and France. Any information then coming back about what's been frozen and indeed what hasn't will then go back to the Italian issuing court and to the claimant ultimately. And that will aid the claimant in any subsequent enforcement action once it's got its judgment. So it prevents those assets from being dissipated. It may also, in practice, force a settlement because parties will negotiate rather than pursue a defence through the courts at a time when they've actually got their assets frozen. So it may encourage settlement and also the early settlement of debts. And that was the policy objective of the Commission when introducing this measure. It was to increase cross-border enforcement of debts. So in terms of the benefits of the EAPO mechanism for claimants, I think the benefits are principally in the post-judgment situation, because I think there claimants will be able to apply for an EAPO without having to provide security, so they're not sort of put at risk or inconvenience of having to provide security, and they could fill in the form for a relatively limited sum and should be able to get either a freezing of an account or at least discover that there is no money to enforce against within participating member states. There's also another benefit of this regulation, and that is that as part of the post-judgment process, the regulation envisages an account searching exercise that banks can carry out. And so if I was a claimant that I'd got my judgment, but I didn't know where the defendant had accounts across Europe, I could fill in an EAPO form, and I could ask the banks in certain jurisdictions to search for me. And this account searching aspect is completely novel in many jurisdictions. That right just doesn't exist currently. And it's certainly novel to have this procedure available across Europe. So one of the advantages is that I might be able to get information about where the defendant has its money, has its bank accounts. Now, just to reiterate, that process is only available in the post-judgment scenario. So I think it will really help judgment debtors. I should also just remind viewers that actually these orders are only going to be available in participating member state courts, so where the proceedings have been ongoing or are about to be commenced in participating member state courts. So that's not in English courts and not in Danish courts, or indeed outside Europe, just in participating member state courts. And in the post-judgment scenario, the court that has jurisdiction to issue the orders is the court that issued the judgment. So if you got your judgment from the German courts, you would go to the German courts for your post-judgment EAPO order. In terms of the EAPO, what are the risks for the defendants? And I think there are a number. I mean, certainly looking back to 2011, when the UK government considered the draft legislation, there were a lot of concerns expressed as part of the consultation process that it was very pro-claimant as a piece of legislation, and it raised real risks for defendants. Although the drafting has been tightened up and the test has been tightened, so it's not quite so pro-claimant, there are, we think, still risks for defendants potentially. I think perhaps the first one is that it's an ex-parte procedure, but also on paper, and it remains to be seen quite how participating member states apply the test that's set out in the regulation. Some, it's anticipated, will apply the test perhaps more liberally than others. In part, that's because it's a matter of discretion of the court. And secondly, they may issue that discretion, perhaps having regard to how they deal with national orders, where the test may be much more liberal. For example, in Holland, it's, as we understand it, much easier to get an attachment order than perhaps elsewhere in Europe. So we do anticipate there'll be real variations across Europe in the application of the relevant test. And that may mean that some courts actually don't scrutinise the application perhaps with as much rigour as other courts, and perhaps develop a reputation for issuing these orders far more easily, and they become sort of EAPO hotspots. And so if you were a defendant, it may be that you, first of all, you face an EAPO, you discover your accounts are blocked. in circumstances where you don't believe that actually there's a real risk that any judgment would not be satisfied, that you don't believe the test is being properly met, or there is some other problem with the application. And I think perhaps for defendants, what might be a difficulty, it's the practical side of getting it set aside. So you may find as a defendant, you lodge your application to set it aside, but then it's very difficult. It takes a long time to get that appeal heard. And so in the meantime, you've got frozen accounts, and that could be very difficult for your business. Another area where there are worries about potential injustices are where if there's an EAPO order issued and it's wrongly issued, perhaps attaching the wrong accounts, your account becomes frozen, perhaps because you've got the wrong name, or there's a mix-up about the name or of the account or the number of the account. So you're just an innocent third party who has its accounts frozen pursuant to this mechanism. And again, it may take a while to get that account unfrozen. In the English system, we know if you want to challenge or you have a concern about a freezing order, or if you're a defendant that has its assets frozen, getting what we call a return date, so getting back before the court to challenge the freezing order in England, is a very speedy process. This can be done very, very rapidly. Now, as to whether that will happen in other participating member states, it's just not clear. Just to recap, I mean, one of the reasons that although the UK courts are not applying the EAPO regulation, but one of the reasons that we need to be alive to this is that companies operating across Europe with bank accounts in Europe may well have their accounts frozen under this mechanism. It doesn't matter where that defendant is domiciled. It can be domiciled in the UK, it can be domiciled outside the EU. Those accounts are potentially within scope and may be frozen, may be attached under this mechanism. There is one interesting aspect of this new regulation, and that is that at the very last moment, a recital was included in the text at recital 48, and that provided, amongst other things, that a claimant applying for an EAPO in participating member states could only come from a participating member state. So effectively, it's excluding UK companies that might be involved in litigation, let's say in France, in Spain, in Italy. If you're a UK claimant, you will not be able, under this rule, it seems, to apply for an EAPO. Now, as to whether that restriction or prohibition would stand up following a challenge on the grounds of discrimination before the European courts, I don't know. But there is this interesting discrepancy. UK companies can not take the benefit of the regulation, but certainly will be exposed to the downside, so they potentially have their accounts frozen. One of the interesting aspects of this regulation is that banks do have a number of arguably onerous obligations under this regulation. First and foremost, they have an obligation to freeze an account sort of immediately, so without delay, upon receipt of the order from their relevant competent authority. They also have an obligation to provide a declaration. So there's a standard form that the bank needs to fill in when it receives an EAPO, and it has to indicate whether it's frozen the account, how much is frozen, and if it hasn't, on what basis it has not frozen the account. So that's within 3 days, it has a duty to do so. And there may be consequences depending on the relevant local law for its failure to do so. So that's one obligation. The second is that for post-judgment account searching orders, account information orders that can be issued as part of this EAPO process. If a bank receives an order to search for an account, they've got to undertake that search again, fill in and complete a form. So that's another aspect that they will be expected to comply with. I think a sort of third element is there are really quite complicated issues that crop up about what precisely can be frozen, what are exempt amounts. And these complicated issues, although they're referred to in the regulation sends parties to national law. So there are going to be variations across Europe. And this is really important for banks. They need to work out, for example, am I permitted, should I be freezing an account that's in a joint name of a defendant? What does the local law say about that? What do I do about exempt amounts, reserved amounts? Do I need to keep anything separate for day-to-day living expenses or business expenses? So all of these are issues that the banks need to have considered as part of this process. Is this going to be a popular measure? I think initially it will be a fairly slow uptake. I think in part because litigants and indeed lawyers won't be that familiar with the process. I think over time, however, it could be much more popular. I anticipate we will see more uptake in the post-judgment situation. I think pre-judgment, litigants may be deterred because they're required to put up security to get one of these orders. And I think they may also consider that national remedies are actually either more effective or just more convenient. But I think in the post-judgment scenario where security is not required, I think these could turn out to be very useful measures indeed, particularly given the account information possibilities. So getting more information from banks about a defendant's bank accounts, I think that aspect could be quite popular.